A major case is now sitting before the U.S. Supreme Court, one that could significantly impact the National Firearms Act, NFA, and its restrictions on short-barreled rifles, commonly known as SBRs. This challenge goes straight to the heart of the Second Amendment, asking the court to declare that the NFA's requirements on SBRs are unconstitutional. If successful, it could mark a turning point in how firearm laws are interpreted and enforced across the country. In today's video, we're covering this critical legal battle that could reshape federal firearm regulation. The case challenges whether SBRs, just like other commonly owned firearms, should be protected under the Second Amendment. The petition doesn't just challenge the NFA's restrictions, it also presses the court to step in and finally resolve ongoing confusion in the lower courts, many of which have openly defied or misapplied Supreme Court precedent. It urges the court to clearly define what types of arms fall under the protection of the Second Amendment. This case follows the Supreme Court's recent decisions to decline review of other key Second Amendment cases, including challenges to rifle and magazine bans. That context adds weight to this petition. While it may face an uphill battle, there's hope among supporters that the Supreme Court will finally take this opportunity to clarify these unresolved issues. The case is Rush v. United States, and it centers around a man named Jamin Rush, who was charged with possessing an unregistered SBR, a violation of the NFA. As most of you already know, the NFA mandates that certain firearms, including short-barreled rifles, must be registered and are subject to federal taxation. Violations can lead to penalties of up to 10 years in prison and a $250,000 fine. In Mr. Rush's case, he filed a motion to dismiss the charges, arguing that the registration requirement infringes on his Second Amendment rights. The court rejected that motion, stating that SBRs are dangerous and unusual firearms not protected by the Constitution, and therefore do not fall under the definition of arms covered by the Second Amendment. After entering a conditional guilty plea, Mr. Rush preserved his right to appeal. He took his case to the Seventh Circuit Court of Appeals, which sided with the lower court. Their decision relied heavily on the Supreme Court's 1939 ruling in United States v. Miller, which upheld restrictions on short-barreled shotguns. However, Mr. Rush and his legal team argue that this precedent doesn't apply in the way the Seventh Circuit claimed. The Seventh Circuit concluded that Miller is still valid, and that the NFA's regulations are consistent with the historical firearm regulations referenced in the Bruin decision. Disagreeing strongly, Mr. Rush has now taken his fight to the Supreme Court. His petition asks the court to overturn the Seventh Circuit's ruling and determine once and for all that the NFA's restrictions on short-barreled rifles are unconstitutional. The specific question now before the Supreme Court is this: does the Second Amendment protect the right to possess unregistered short-barreled rifles that are in common use for lawful purposes? In the petition, the NRA argues that ever since the Supreme Court issued its decision in Bruin, courts across the country have been struggling to apply the new standard the court set. That decision reshaped how Second Amendment cases are to be evaluated, and it left many lower courts divided on key questions, especially on what qualifies as a bearable arm protected under the Constitution. The NRA's petition highlights that this particular case presents the Supreme Court with an opportunity to resolve some of those ongoing disagreements. While the case specifically addresses short-barreled shotguns, SBS, and the restrictions imposed by the National Firearms Act, NFA, it raises broader questions that could impact how courts interpret firearm laws nationwide. The petition argues that the court should use this case to settle the debate once and for all. What kinds of arms are actually protected under the Second Amendment? What makes this petition especially significant is that it's not just about SBRs or SBSs in isolation. The broader legal challenge is aimed at getting the Supreme Court to define which arms, whether rifles, handguns, magazines, or other firearm types, are constitutionally protected. If the court rules in favor of Rush, the decision could affect existing state-level bans on rifles, standard-capacity magazines, and other firearm components, many of which are currently being defended on the grounds that they fall outside the scope of Second Amendment protections. The petition argues that the Second Amendment guarantees the right to possess all bearable arms that are commonly used for lawful purposes, including short-barreled rifles. It challenges the Seventh Circuit's conclusion that SBSs are not arms under the Constitution. According to the NRA, the Seventh Circuit created an artificial standard, one that, by its very design, is almost impossible to satisfy. For instance, the court simultaneously dismissed the popularity and lawful use of short-barreled rifles as being of little value, while also claiming that Rush failed to prove they are commonly used for lawful purposes. The contradiction in reasoning is clear. Even though the court stated that its test is compatible with the Bruin decision, the authors of Bruin and Heller themselves have criticized such approaches for being inconsistent with Supreme Court precedent. To support its argument, the petition presents statistics showing there are at least 532,000 registered short-barreled rifles in the United States. That figure, though, is likely outdated. Once you factor in how the ATF has recently attempted to reclassify brace-equipped pistols as SBRs, the actual number is significantly higher. Yet the Seventh Circuit dismissed this evidence, ignoring the widespread lawful ownership of these firearms. The federal government, through agencies like the ATF, claims that SBRs are not widely owned or used for lawful purposes. But the data clearly shows otherwise. Ownership is not only common, it's substantial. Still, the Seventh Circuit essentially argued that the number doesn't matter, brushing aside one of the main points laid out in Bruin regarding common use. Another major argument raised in the petition concerns the historical context the government uses to justify the NFA. The NRA argues that the registration and taxation requirements under the NFA do not have meaningful historical parallels. The historical laws cited, such as colonial-era militia regulations or tax laws, are fundamentally different from the modern regulatory framework imposed by the NFA. According to the petition, none of those historical laws offer a valid comparison. The petition also takes aim at the government's reliance on the 1939 United States v. Miller case. Although this decision has been used repeatedly to justify federal gun regulations, the NRA points out that Miller never actually ruled that short-barreled shotguns, or by extension, short-barreled rifles, are unprotected by the Second Amendment. In fact, Miller focused specifically on short-barreled shotguns, not rifles. It also didn't address the situation we're in now, where these types of firearms are owned in the hundreds of thousands, if not millions, for legal, everyday purposes. That raises a key question. If these firearms are clearly in common use, why should they fall outside the protection of the Second Amendment? In this section of the petition, the NRA makes an important argument about how the Miller decision has been misunderstood. They point out that the Supreme Court in Miller did not conclude that short-barreled shotguns were protected by the Second Amendment. Instead, the ruling simply allowed the NFA's restrictions to apply to arms that are not constitutionally protected. In other words, Miller only upheld the NFA in the context of unprotected weapons. It didn't say anything about what should happen when a weapon is protected under the Second Amendment. The NRA argues that this distinction is critical. If short-barreled rifles today are widely owned and used for lawful purposes, and clearly fall within the category of protected arms, then the NFA's restrictions on them become highly questionable. They argue that applying the NFA to protected arms would be unconstitutional, which is something Miller never addressed because it wasn't dealing with weapons in common lawful use. So the NRA believes the Seventh Circuit's interpretation of Miller is incorrect. The ruling in Miller does not support the idea that the NFA can restrict any firearm the government chooses. It only allows for restrictions on weapons that fall outside the scope of the Second Amendment. And that's the key question here. What happens when a firearm is protected? If short-barreled rifles are indeed common and lawfully owned, which evidence shows they are, then under the Second Amendment, they should be protected, and the NFA's restrictions should be struck down, at least as applied to those arms. Ultimately, the NRA is asking the Supreme Court to grant certiorari, to take up the case and finally provide clarity on the scope of the Second Amendment. Specifically, they want the court to define which types of arms are protected and to what extent laws like the NFA can be applied to those arms. This is an area where there's been a lot of confusion and disagreement in the lower courts, and the Supreme Court has yet to clearly resolve it. This is why the case is so important. It isn't just about one law or one type of firearm. This challenge could have far-reaching implications for how courts handle firearm restrictions across the country. The question of whether short-barreled rifles, and potentially other types of commonly owned firearms, are protected under the Constitution could affect the legal status of rifle bans, magazine capacity limits, and even so-called assault weapon bans in various states. As for whether the Supreme Court will take this case, that's still uncertain. The court recently declined to hear challenges to state-level rifle and magazine bans, which might suggest they aren't ready to address these issues just yet. And since this case directly challenges the NFA, it may be seen as a bigger leap than the others. However, the fact that this petition is backed by the NRA and comes out of the Seventh Circuit might give it more weight. Additionally, Justice Kavanaugh, in a recent statement related to the court's refusal to hear a rifle ban case, mentioned that similar issues could be taken up in a future term. It's also worth watching how the federal government responds to this petition. Since this is a challenge to the NFA, the government will be defending the law. If the current administration follows the approach seen in the Fifth Circuit's Peterson suppressor case, they might argue that the NFA is constitutional, but at the same time recommend that the Supreme Court hear the case to provide guidance on the issue. When the federal government asks the court to review a case, the court often agrees. In short, this is a case with significant implications, not just for short-barreled rifles and the NFA, but for Second Amendment law as a whole. It has the potential to reshape how courts evaluate firearms regulations and could impact gun laws in many states across the country. We'll be keeping a close eye on how this develops. If there are any updates, I'll be sure to share them with you. Thank you all for watching. If you found this breakdown helpful, please like the video, leave a comment with your thoughts, and subscribe to the channel so you don't miss any future updates.